Dear learners, welcome to this session. Today we will be discussing Juvenile Justice, Care and Protection of Children Act 2015 and Human Rights. In the earlier session, you must have seen that we have discussed the POSCO Act along with the definitions given under the Juvenile Justice, Care and Protection Act. Now we will talk about the legislation. Chapter 2 talks about general principles of care and protection of children, and these are very important. You are talking about children being trafficked. You are also talking about human rights issues related to children being trafficked. And now we have a Juvenile Justice Act which talks about general principles of care and protection of children. Then why do we see beggars on the street as children? Why do we see children in domestic help? Why do we see children on the dhaba and hazardous employment? If these principles are followed, then we do not have cases of child trafficking. So the first principle is principle of presumption of innocence. Any child shall be presumed to be an innocent of any malafide or criminal intent up to the age of 18 years. And this is very important, The child grows in the society. So the society is responsible for the overall development of the child. So if the environment in the family is not conducive for the overall development of the child, then you cannot say that the child is not innocent. Principle of dignity and worth. All human beings shall be treated with equal dignity and rights. Just remember the UDHR principles, remember your Protection of Human Rights Act, and also remember your Article 21. Then, principle of participation. Every child shall have a right to be heard and to participate in all processes and decisions affecting his interest, and the child's view shall be taken into consideration with due regard to the age and maturity of the child. This is very important, When you are making a program for the child, then do involve children. Otherwise, maybe you are not addressing their issues, their needs. And if the needs and issues are not reflected in your programs and policies, then you don't find it properly being implemented at the ground level. Principle of best interest. All decisions regarding the child shall be based on the primary consideration that they are in the best interest of the child and to help the child to develop full potential. This is very important. Whenever you take a case of a child, then you have to follow this principle of best interest. Principle of family responsibility. The primary responsibility of care, nurture and protection of the child shall be that of the biological family or adoptive or foster parents, as the case may be. Now I am giving you a case of nuclear family where children are looked after by house help people. What kind of nurturing we find for these children? Children who are 12 to 13 hours before the internet, on the laptop, on the iPads. So the family responsibility element is somehow missing. Children who have been abandoned by their parents, children who are neglected by their own parents, or are living in abusive environment. Either the parents are fighting with each other, abusing each other, and do not have a positive growth or positive vibration in the family. So we have to address all these issues when we are talking about principle of family responsibility. Principle of safety. All measures shall be taken to ensure that the child is safe and is not subjected to any harm, abuse or maltreatment while in contact with the care and protection system and thereafter. So, the child has to be safe at all places. So if the child is not safe in the school, we have seen the incidences. If the child is not safe with the relatives or the family members at home or his or her own parents, or if the child is not safe in all these homes which are mentioned under the act, then principle of safety is looked down upon and not followed and implemented properly in cases of these children. And many a times even we do not hear the children. So if the child wants to speak up about some abuse, then the parents will not like to hear it, or maybe will say that do not speak about it because you are not telling the truth. Or if you talk about this incident to others, my family reputation is in danger. So you have to talk about the best interest of the child and not about your family reputation. Because if the child has a fear at home, in school, or at different places, then how will the child develop to the best of his capacity or develop to full potential? Positive measures. All resources are to be mobilized, including those of family and community, for promoting the well-being, facilitating development of identity, and providing an inclusive and enabling environment to reduce vulnerabilities of children and the need for intervention under this act. So it is very important, we have so many positive measures for children. One was the midday meal. So somehow the children are not getting the midday meals these days, so we have to find about alternatives. How will the child get a balanced diet, a nutritious diet sitting in their homes? We find lot of children in India dying out of malnutrition. So the positive measures made by the government of India and by the state governments should be implemented at the grassroots levels. Then we have principle of non-stigmatic semantics. Adversarial or accusatory words are not to be used in the processes pertaining to a child. You have to ensure the child's dignity and worth. So if you abuse the child, or if you give a stigma that you have been involved in this crime, so you are a thief, or a child who was involved in sex trafficking, so you cannot name or you cannot put them stigma or labels. So you have to protect their dignity. Principle of non-waiver of rights. No waiver of any of the rights of the child is permissible or valid, whether sought by the child or person acting on behalf of the child, or a board or a committee, and non-exercise of a fundamental right shall not amount to waiver. Lot of children are not aware of their fundamental rights. So do you think that the rights are not available to them? No, the rights are available to them. It is that the law has not been implemented, and we need to implement the law to enforce the law properly. Principle of equality and non-discrimination. There shall be no discrimination against a child on any ground, including sex, caste, ethnicity, place of birth, disability, and equality of access, opportunity, and treatment shall be provided to every child. So if this principle of equality and non-discrimination is implemented properly in India, we will not find any vulnerable child. Principle of right to privacy and confidentiality. Every child shall have the right to protection of his privacy and confidentiality by all means and throughout the judicial process. So you have to maintain the confidentiality of a case in case where the child is involved. Principle of institutionalization as a measure of last resort. A child shall be placed in institutional care as a step of last resort after making a reasonable inquiry. Principle of repatriation and restoration. Every child in the juvenile justice system shall have the right to be reunited with his family. We all are social beings at the earliest and to be restored to the same socio-economic and cultural status that he was in before coming under the purview of this act, unless such restoration and repatriation is not in his best interest. So if the family environment is not safe, then there is, this will not be implemented. Otherwise, the child needs his family. We are born and we have a bond with our family members. So the child needs to be reunited with his family members, then only he will be able to reintegrate in the society. Principle of fresh start. All past records of any child under the juvenile justice system should be erased except in special circumstances. Principle of diversion. Measures for dealing with children in conflict with law without resorting to judicial proceedings shall be promoted unless it is in the best interest of the child or the society as a whole. Principle of natural justice. Basic procedural standards of fairness shall be adhered to, including the right to a fair hearing, rule against bias, and the right to review by all persons or bodies acting in a judicial capacity under this act. This is very important, that you have to have a fair hearing. Then chapter 3 talks about Juvenile Justice Board, very important provision, section 4. Notwithstanding anything contained in the Code of Criminal Procedure 1973, the state government shall constitute for every district one or more juvenile justice boards for exercising the powers and discharging its functions relating to children in conflict with law under this act. Then, we have the constitution of Juvenile Justice Board. A board shall consist of a metropolitan magistrate or a judicial magistrate of first class, not being chief metropolitan magistrate or chief judicial magistrate, herein referred to as principal magistrate, with at least 3 years of experience and 2 social workers selected in such manner as may be prescribed, of whom at least one shall be a woman. A child-friendly provision of having a woman in this board. Forming a bench, and every bench shall have the powers conferred by the Code of Criminal Procedure 1973 on a metropolitan magistrate, or as the case may be, a judicial magistrate of first class. No social worker shall be appointed as the member of the board unless such person has been actively involved in health, education, or welfare activities pertaining to children for at least 7 years, or a practicing professional with a degree in child psychology, psychiatry, sociology, or law. So we have seen that we have a magistrate, we have 2 social workers, and the social workers are very much involved in, child psychology, psychiatric, or sociology, or law, and are related to health, education, welfare activities. Then what happens that the law is not implemented properly and we find cases of child abuse. So there is a need to have committed people throughout their tenure so that they are able to protect these vulnerable children who are in need of having been protected because they cannot protect and speak for themselves. No person shall be eligible for selection as a member of the board if he has any past record of violation of human rights or child rights, has been convicted of an offense involving moral turpitude, or such conviction has not been reversed or has not been granted full pardon in respect of such offense. So as I said, we have very good law. but we lack implementation of law. We lack awareness about the law. So the more we are aware about these laws, the more stringently will we be able to implement these laws, and for that we need committed people to work in these boards. Or has been removed or dismissed from service of the central government or a state government or any undertaking or corporation owned or controlled by the central government and state government, has ever indulged in child abuse or employment of child labor or any other violation of human rights or immoral act. Then we talk about induction, training and sensitization of these people. The state government shall ensure that induction, training and sensitization of all members, including principal magistrate of the board on care, protection, rehabilitation, legal provisions and justice for children as may be prescribed is provided within a period of 60 days from the date of appointment. And this is very important, that you need to train these people, sensitize these people so that they are able to perform their functions in the best interest of child. Termination. The appointment of any member of the board except the principal magistrate may be terminated after holding an inquiry by the state government if he has been found guilty of misuse of power vested under this act, fails to attend the proceeding of the board consecutively for 3 months without any valid reason, or fails to attend less than 3/4 the sittings in a year, becomes ineligible for under subsection 4 during his term as a member. Then placement of person who ceases to be a child during process of inquiry. When an inquiry has been initiated in respect of any child under this act, and during the course of such inquiry, because that is a time frame that takes time to complete the inquiry. So during the course of such inquiry, the child completes the age of 18 years, then notwithstanding anything contained in this act or in any other law for the time being in force, the inquiry may be continued by the board and orders may be passed in respect of such person as if such person has continued to be a child, and this is as per the best interest of the child. Placement of persons who committed an offence when person was below the age of 18 years. Any person who has completed 18 years of age and is apprehended for committing an offence when he was below the age of 18 years, then such person shall, subject to the provisions of this section, be treated as a child during the process of inquiry. Very important, you have committed a crime when you were below 18 years of age, and now you have been taken away by the police officers, and then under the apprehension that you have committed that offence, now you are an accused. So you will be treated as if you were a child. The person referred to in subsection 1, if not released on bail by the board, shall be placed in a place of safety during the process of inquiry. The person referred to in subsection 1 shall be treated as a procedure specified under the provisions of this act. Then procedure is very important, section 7. The board shall meet at such time and shall observe such rules in regard to the transaction of business at its meeting as may be prescribed, and shall ensure that all procedures are child friendly and that the venue is not intimidating to the child and does not resemble as regular court. A child in conflict with law may be produced before an individual member of the board when the board is not sitting. A very proactive law on children. A board may act notwithstanding the absence of any member of the board, and no order passed by the board shall be invalid that the member was not there during any stage of proceeding, provided that there shall be at least 2 members, including the principal magistrate, present at the time of final disposal of the case, or in making an order under subsection 3 of the section 18. In the event of any difference of opinion among the members of the board, in the interim or final disposal, the opinion of majority shall prevail, and if there is no majority, then the opinion of the principal magistrate shall prevail. Powers and functions and responsibilities of the board are there in section 8. We will focus on the functions. Ensuring the informed participation of child and the parent or guardian in every step of the process. Ensuring that the child's rights are protected throughout the process of apprehending the child, inquiry, aftercare and rehabilitation. Ensuring availability of legal aid for the child through the legal services institution. Wherever necessary, the board shall provide an interpreter or translator. You have a different language, so you need an interpreter who will interpret, or translate and make you understand the court proceedings. Having such qualification, experience, and on payment of such fee as may be prescribed to the child if he fails to understand the language used in the proceeding. This is as per the principle of natural justice. Directing the probation officer on in case a probation officer is not available to the child welfare officer or a social worker to undertake a social investigation into the case and submit a social investigation report within a period of 15 days from the date of first production before the magistrate before the board to ascertain the circumstances in which the alleged offence was committed. So, you have to prepare a social investigation report. Adjudicate and dispose of cases of children in conflict with law in accordance with the process of inquiry specified in section 14. Transferring to the committee matters concerning the child alleged to be in conflict with law, stated to be in need of care and protection at any stage, thereby recognizing that a child in conflict with law can also be a child in need of care simultaneously, and there is a need for the committee and the board to be both involved. Disposing of the matter and passing a final order that includes an individual care plan for the child rehabilitation, including follow-up by the probation officer or the district child protection unit or a member of a non-governmental organization as may be required. Conducting inquiry for declaring fit persons regarding care of children in conflict with law. So, we will not have any child abuse at the places of shelter if the functions are done properly. Conducting at least one inspection visit every month, and we can use technology to have an inspection of residential facilities for children in conflict with law and recommend action for improvement in quality of services to the district child protection unit and the state government. Order the police for registration of first information report for offences committed against any child in conflict with law under this act or any other law for the time being enforced on the complaint made in this regard. Order the police for registration of FIR for offences committed against any child in need of care and protection under this act or any other law for the time being enforced on a written complaint by a committee in this regard. Conducting regular inspections of jails meant for adults to check if any child is lodged in such jails, and take immediate measures for transfer of such a child to the observation home and any other function as may be prescribed. This is very important, in times of changing dimension, in changing, times, you need the law to be flexible, and this provides the flexibility that any other function can be there in N. Apprehension of child alleged to be in conflict with law. The process has been defined in section 10. As soon as a child alleged to be in conflict with law is apprehended by the police, such child shall be placed under the charge of the special police officer, juvenile police unit, or the designated child welfare police officer who shall produce the child before the board without any loss of time, but within a period of 24 hours of apprehending the child, excluding the time necessary for journey. So from remote places, if you are bringing the child, then the journey time will not be included from the place where such child was apprehended, provided that in no case a child alleged to be in conflict with law shall be placed in a police lockup or lodged in a jail. This is very mandatory provision, that you cannot put the child in lockup or in jail. The state government shall make rules consistent with this act to provide for persons through whom any child alleged to be in conflict with law and may be produced before the board, to provide for the manner in which the child alleged to be in conflict with law may be sent to an observation home or place of safety, as the case may be. Role of persons in whose charge child in conflict with law is placed is under section 11. Any person who is in charge of a child in conflict with law is placed shall, while the orders is in force, have responsibility of said child. So you are responsible for the child as you were his parents, or for his maintenance, provided that the child shall continue in such person's charge for the period stated by the board, notwithstanding that the said child is claimed by the parents or any other person, except when the board is of the opinion that the parent or any other person are fit to exercise charge over such child. So this is a very important provision. Bail to a person who is apparently a child alleged to be in conflict with law. When any person who is apparently a child and is alleged to have committed a bailable or non-bailable offence is apprehended or detained by the police or appears or brought before the board, such person shall, notwithstanding anything contained in CRPC or in any other law for the time being in force, be released on bail with or without surety, or placed under the supervision of a probation officer or under the care of any fit person, provided that such person shall not be so released if there appears reasonable ground for believing that the release is likely to bring that person into association with any known criminal in human trafficking, or expose the said person to moral, physical or psychological danger, or the person's release would defeat the ends of justice and the best interest of child. And the board shall record the reasons for denying the bail and circumstances that led to such a decision. So it will write, when such person having apprehended is not released on bail under subsection 1, the officer in charge of the police station, such officer shall cause the person to be kept only in observation home in such manner as may be prescribed until the person can be brought before the board. When a person is not released on bail under subsection 1, the board, it shall make an order sending him to an observation home or a place of safety, as the case may be, for such period during the pendency of the inquiry regarding the person as may be specified in the order. So it is very important that you will keep that person in observation home or place of safety and not in lockup or jail. When a child in conflict with law is unable to fulfill the conditions of bail order within 7 days of the bail order, such child shall be produced before the board for modification of the condition of bail. This is also a child-friendly provision. Information to parents, guardians or probation officer. Where a child alleged to be in conflict with law is apprehended, the officer designated as child welfare police officer of the police station or the special juvenile police unit which such child is brought shall, as soon as possible after apprehending the child, inform the parents or guardian about the child if they can be found, and direct them to be present at the board before when the child is produced. And the probation officer, or if no probation officer is available, a child welfare officer, for preparation and submission within 2 weeks to the board, a social investigation report containing information regarding the antecedents and family background of the child and other material circumstances likely to be of assistance to the board for making the inquiry, because on this basis of this report only the board will decide whether the child is safe with the family or not. When a child is released on bail, the probation officer or the child welfare officer shall be informed by the board. Now we have seen the functions of the Juvenile Justice Board. We have seen the composition of the board. We have seen how can we have the principles, the general principles for a child welfare legislation. So if they are followed in true sense and implemented strictly at all level, monitored in a transparent way by using technology, then we will not have a case of child abuse, and the children who are in conflict with law or in need of care and protection will be taken care by this legislation. Thank you all for listening. Stay safe.